Hi everyone, it's me, Teresa Perrin, and I just wanted to discuss two very important things with Mullen Automotives. And it's very important that this news gets out there so that people, number one, are not disappointed with the first thing that I need to discuss. And number two, it's regarding the voting. One of the subjects that we're voting on is changing the incorporation from Delaware to Maryland. And I didn't think it was very important, but in fact, it's very important. And I'm going to tell you exactly why in this video. I'm going to start with something that is going around regarding an article from Eddie Pan with Investor Palace. If you follow me on Twitter, you already know I made a comment regarding this, but I want to discuss it with you so that nobody's set up for a disappointment tomorrow. So let's get started. Please remember, nothing I say is financial advice. Always do your own duty, and please make sure you stay to the end to listen to what I'm going to tell you about this vote, because your vote is going to matter very much with this, and this is probably one of the most important things we're voting on. Okay, so Eddie Pan used to write very bullish articles or neutral articles on Mullen. They weren't really negative, but as of late, I find that his articles are very bearish, and I'm not quite sure what the switch is, but he is the person who brings most of the articles regarding Mullen from Investor Palace to us. And today, this came out from him. It says, Mullen stock dips ahead of November 30th deadline. First of all, guys, I don't know where he's getting a deadline from because there is no deadline. So I am very confused by this. And if I'm mistaken, please comment below. But my understanding was that the vans were sent back by Bollinger after they wanted some changes done to them. I'm sorry, by DPL, excuse me. Were sent back by DPL after they wanted some changes done to them. And you know, there was no deadline of November 30th or any date. They just wanted to have changes, and then the vans could be delivered as soon as November 30th, but this was not a deadline. I mean, I'm very, very, very confused by why this is coming out, and I feel like it's one of those situations that sets people up for disappointment and a dump. I mean, I don't think it's going to dump much more than it already has, but to be honest with you, I don't understand where this is coming from. It says shares of Mullen Automotive stock hit a 52-week low of 19 cents today, as there is still no word on whether Delpac Logistics has requested 300 Class 2 cargo vans. In July, the two companies signed a binding agreement for DPL to purchase up to 600 vans over the next 18 months. Exactly, 600 vans over 18 months. There was no time frame of when they would get this delivery. It says the first 300 vans could be, keyword could be, delivered as soon as November 30th at the request of DPL. Delpac is an Amazon logistics partner that serves shipping areas in Indiana. Again, guys, I would expect that this got delayed because the initial one that they test drove was sent back with some changes that they wanted done to the vans to make it more suitable for their drivers. So I don't know why this is coming out, but I just don't want anyone to be disappointed and have expectations tomorrow that perhaps are not met. Now, hopefully David puts out some kind of PR tomorrow, at least saying where we stand or something, because I think any kind of bullish sentiment that would come from him could send this soaring. We are at, all-time lows. So it's a perfect opportunity to acquire in my position. I mean, seriously, we're at 20 cents at the moment. Can't really go, well, it could go to zero, but I don't think that's going to happen. I think there's a lot of upside opportunity here. And again, please do not let dates and this kind of FUD upset you, because it's just not worth it. Like I said, I think this was taken off the timeline when this came back. Now, moving on to the most important part of this video, let's discuss this incorporation and what it entails. All right, guys, first of all, I want to give a huge shout out to Raj Kumar Galati on Twitter, because he sent me this article and it is very helpful, which is why I wanted to make this video and share it with everybody. So this is the 10 reasons to consider incorporating in Maryland instead of Delaware. And some of these are going to be very relevant to what's going on with Mullen. So number 1, no franchise tax in Maryland. I'm going to skip that because that's not really what I'm getting at. Reason number 2, ability of Maryland corporations to increase authorized shares without stockholder approval under optional charter provisions. Ding, 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 ding. Red flag, guys. Listen to this. I'm going to repeat it. The ability of Maryland corporations to increase authorized shares without stockholder approval under optional charter provisions. So by switching to Maryland as their corporation, if we vote for this to be allowed, then David Mitchery is allowed to increase the number of shares without a vote from the stockholders at any time. I'm going to give you the breakdown that it says underneath because I think this is very important. A corporation can only issue up to the number of shares of stock authorized by its charter. Under the Delaware General Corporation Law, and the corporation laws of nearly every other state, a charter amendment to change the number of authorized shares requires stockholder approval. For a publicly held company, the stockholder approval process is costly and can take several months. Far too long when there is an urgent need or desire to raise capital. The Maryland General Corporation Law permits a Maryland corporation to include in its charter a provision authorizing the board of directors to amend the charter to change the number of authorized shares without, I repeat, without stockholder approval. Having this flexibility can enable a company to be more opportunistic in the management of its capital. Guys, it's no secret that Mullen, is very dilutive in nature, and much of this is to be expected because it is a startup company. However, I think this is given a lot of power to David Mitchery if we vote for this, because I feel that it's giving him complete control. And look at the things he's already done to try to go around stockholders to increase shares and to do things like the special vote that the amended share where he would get all the votes to be able to vote for the reverse split that he just did. Go back and watch my videos that I did on that. You know, guys, that's borderline BS in my opinion. And, it's not really right to a public company when you have shareholders to make that decision. And I mean, I kind of understand why he did it. I think there's a lot going on behind the scenes that we're not aware of. But then when I see the dilution and just the horrible deals that he's been putting out there with these warrants, it's like, it's very, very awful funding the way he's been going about this dilution. And it's concerning, to be perfectly honest. Do I think we can overcome it? I'm hopeful, which is why I'm invested in this long term. But I don't like the fact that he's trying to basically cut out our rights as shareholders to vote upon these things, and I'm concerned. So I am bringing this to your attention right now that if you vote to allow him to change the corporation from Delaware to Maryland, then you are saying that he has the right to increase shares whenever he feels fit. All right, that's a problem, in my opinion. Reason number 3, no higher duty or greater scrutiny applicable to board actions in corporate control context under Maryland law. You can go back and read this if you like. I will slowly so you can screenshot it. I'm just going to go on to the things that I feel are most important. Greater liability protection for directors and officers under Maryland law. Again, this would be beneficial to him, but I'm going to let you read this on your own. I don't want to make this video last forever. You can pause it, screenshot, do what you like. Reason number 5, broader director and officer indemnification under Maryland law. So basically what this does is It allows the person who's covered or who is threatened to be made a party of any legal proceedings other than an action by or in the right of the corporation, commonly referred to as a stockholder, derivative action, or derivative proceeding, against expenses, attorney fees, judgment, fines, and amounts paid in settlement actually and reasonably occurred by the covered person. Basically, guys, this is just giving them, more protection. So you can go back and read this if you'd like as well. Reason number 6, stronger anti-takeover protection available under Maryland law. All right, guys, this I'm going to allow you to read as well because it's just talking about like a shareholder takeover and, other things that can happen. Control share acquisition statute, rights plans, effective provisions regarding of unsolicited takeovers. Reason number 7, more limited stockholder inspection rights under Maryland law. This is another one that you should know about. The Delaware GCL provides that any stockholder, regardless of the number of shares held and how long he or she has held his or her shares, generally has the right to inspect the corporation's stock ledger, list of stockholders, other books and records, and subject to certain conditions, a subsidiary's books and records, provided that the stockholder has a proper purpose for doing so and satisfies certain procedural requirements. A stockholder may file suit to compel production of these items if the corporation refuses to permit the inspection or does not reply to the stockholder's demand within 5 business days. So Maryland stockholders inspection statute differs significantly from Delaware's. Under the Maryland GCL, only a holder or group of holders of 5% or more of any class of the corporation's stock for at least 6 months has the right to inspect the corporation's stock ledger, list of stockholders, books of account, and statement of affairs setting forth in reasonable detail the corporation's assets and liabilities of a reasonably current date. In the case of a request for a statement of affairs or list of stockholders, the information must be provided to the stockholder within 20 days. Any stockholder, regardless of number of shares owned and regardless of whether he or she became a stockholder, may inspect the company's bylaws, stockholder minutes, annual statement of affairs, and any voting trust agreements. These items must be made available to the stockholder within 7 days. Any stockholder also may request a statement showing all stock and securities issued by the corporation during a specified period of not more than 12 months before the date of request. This information must be provided to the stockholder within 20 days. All right, guys, the reason why I feel that this is important is because it limits shareholders' rights, okay? And that's what basically, as a stockholder, you need to realize whether you have a small position or a large position that you have rights. And if you want to see these records, then you should be able to. So keep in mind that if you're voting on this, you're signing away the rights for certain things if you do not own more than 5% of the company. Now, this may not affect any one of us at any time, but there's something to be said for that. And why would a company not want you to be able to see their books? Just saying. And remember, I'm long, so I'm bullish on Mullen Automotives. Reason number 8. More limited appraisal rights under Maryland law and ability of Maryland corporations to eliminate appraisal rights altogether. So, under the Delaware GCL, stockholders of a corporation who are voting on a merger or consolidation generally are entitled to dissent from the transaction and obtain payment of the fair value of their shares in cash, commonly referred to as appraisal rights. These rights do not apply, however, if the corporation's shares are listed on a national securities exchange or are held by 2,000 or more holders of record, and 2, except for cash in lieu of fractional shares, interests are being exchanged for A, shares of the corporation surviving or resulting from the merger or consolidation, or B, shares of other corporations which are listed on a national security exchange or held of record more than 2,000 holders. Thus, even if the target corporation shares are listed on a national security exchange, the stockholder will have appraisal rights. if any portion of the merger's consideration will be payable in cash, other than cash in lieu of fractional share interest. Appraisal rights can frustrate a would-be acquirer's desire to cap the amount of cash it will pay in a merger. While the stockholders of a Maryland corporation being acquired in a merger are generally entitled to appraisal rights, with limited exception, these rights do not apply if the corporation's stock is listed on a national securities exchange, regardless of the form of merger consideration. The Maryland GCL also permits any Maryland corporation, irrespective of whether its stock is listed in a national securities exchange, to eliminate the appraisal rights of its stockholders through a charter provision. The Delaware GCL does not allow a Delaware corporation to do this. Now, again, guys, this may never ever come into play, but it's important to know that, this is what it does. So should there be a buyout, or some other transaction that would apply, then this is going to affect our rights as shareholders. Again, it may never even occur, so that's probably not super important. The most important thing, obviously, is the first thing I discussed with you. And we'll go back to that at the end, and I'll repeat it. Reason number 9, simpler and more flexible standard under Maryland law for ability to make distributions. Again, we're not even at a point of distributions right now, so we don't really need to get into this, but you can screenshot it and read it. Or guys, I will try, and please, my computer skills are horrible, to put a link to this if I can in the notes. Just give me a day because I'm on my way to water aerobics in a minute here. So I may not be able to do it until later tonight. But I want to give you the link. Reason number 10, ability of publicly held Maryland corporations to implement reverse stock splits without stockholder approval. Okay, guys, this is the second thing that I wanted to bring to your attention. Very, very important. I'm going to repeat it. Reason number 10, the ability of publicly held Maryland corporations to implement reverse stock splits without stockholder approval. Do we see a pattern here? Comment below. I'd like to know your thoughts on this, but let me read to you what it says specifically. A reverse stock split combines a corporation's outstanding shares into a smaller number of shares. This has the effect of increasing the market value of each share remaining outstanding after the reverse stock split. The primary reason a publicly held company will have for doing a reverse stock split is to remain in compliance or to return to compliance with the minimum per share requirement of the stock exchange on which shares are listed. Generally, $1 per share for both the New York Stock Exchange and the NASDAQ stock market. Because a reverse stock split is done either by increasing the par value of shares or reducing the corporation's stated capital, stockholder approval is normally required. Again, stockholder approval is normally required, which is why we're voting on this at the annual meeting. As noted above, seeking that approval can be expensive and time-consuming. The Maryland GCL provisions that, unless prohibited by the corporation's charter, the board of directors of a Maryland corporation with a class of equity securities registered under the Securities Exchange Act of 1934 can amend the charter without stockholder approval to achieve a reverse stock split by combining shares at a ratio of not more than 10 shares into one share in any 12-month period. The Delaware GCL contains no such provisions. Delaware has long been the incorporation state of choice for most publicly held companies and companies with aspirations of going public. Yet there are compelling reasons, 10 of them discussed above, for these companies to consider incorporating or reincorporating in Maryland instead. They owe it to themselves and their stockholders to take a close look at Maryland. So guys, again, the two biggest things that I see here are the ability of publicly held Maryland corporations to implement reverse stock splits without stockholder approval, and then way back up here, let me find it. The ability of Maryland corporations to increase authorized shares without stockholder approval under optional charter provisions. Wouldn't you know, both of those are things that we are voting on at this meeting. If we vote to allow David Mitchery to change the corporation from Delaware to Maryland, we are giving him the power at any time to implement a reverse stock split without our approval and to increase the number of authorized shares without our approval. So if you vote yes, don't be surprised when you start to see more shares being diluted or additional stock splits or who knows what else, guys, because basically we're giving up any control that we have by doing this. So it's up to you how you want to vote. I can't tell anybody what to do, but personally, I'm voting hell no. I absolutely will not authorize this. But guys, there's a lot of us that go into this, so please make the decision for yourself. Do not let my decision influence you in any way. You know, I'm just sharing with you the facts that everybody needs to know, because if you're like most people, including myself, you probably see that and don't think it's all that important, when in fact it's very, very important, and this is why. Thank you so much for watching. Please like and share this video. Stockholders need to be aware of this.